All right, welcome back to my closet. We're going to deal with summary judgment, and it took a long time to upload and process and all that last PowerPoint. So I'm going to break this one into three, maybe two um, different things. So there's three issues for you to think about, um, and again, I think it will help you enormously when you read Celotex. And if you haven't read it, do it now. I will reread it now. When the court at the beginning says, well, here's what the moving party showed, and then it says, and here's what I think it was the petitioner, the plaintiff, did in response, and then here's what the Celotex did in response to that. Think about motion, response, reply, and realize that really what the court is saying is the defendant filed a motion, and here's what it showed in its motion. The plaintiffs file a response to that motion, and here's what they showed in their response. And in its reply brief, here's what Celotex showed. So when you read that, realize it's describing a motion, a response, and a reply. And it's looking at, and this whole case is about what does it take for the moving party to meet its burden of production. That's what all Celotex is really about. And it's ultimately very simple, really very, very simple. Some of the notes that Yezel has, or one of the notes he has afterwards, I think kind of confuses things a bit, but I'll get there in a second. So there's three issues you need to think about. Number one, did the movement meet its burden of production? And its burden of production is going to be one of two things. One is to negate, to prove there is no evidence of something. Very hard to do, but not impossible. The motion in bias is probably that kind of a case, where in that case the defendant proved no insurance company would give somebody a $1 million policy if they use cocaine. They actually proved that and negated an element of the plaintiff's case there. You could argue about whether that's kind of it or not. The second kind of way that a defendant can meet its burden of production is a little bit weirder in terms of understanding it, but it is really important to understand because it is the much more common way that defendants move for summary judgment. And it is to show the plaintiff doesn't have evidence. Now that sounds strange, but think about it for a second. Under the first approach, I come in as a defendant and I have to prove a fact that the plaintiff has the burden on. So that you can do that, they did it in bias, but the other way to do it is to come in and say, after discovery, the plaintiff has had the time to go to discovery, and look, Judge, I'm going to show the discovery material that was produced, and we'll come back to that. You don't show all of it. And I am showing you that the discovery in the case shows the plaintiff has no evidence of an element of their claim. It sounds a little bit weird, but it's a lot easier to show the plaintiff doesn't have any evidence than to prove a fact, especially when you don't have the burden of proof on it at trial. So, two very, very different ways to get summary judgment. If the defendant meets its burden of production in its motion, then the non-movement has a burden of production in its response. The non-movement, it's one of two things, but primarily it's showing that there are facts favoring the non-movement that show that we need to get to trial. In other words, in the bias case, there was one insurance company out there that did give insurance policies to cocaine users. And then ultimately, there's a reply brief, but ultimately, when it's all done, the question that the court asks is, did the movement carry their burden on summary judgment, the burden of persuasion, to show that there was no issue of disputed fact and no reasonable jury could find for the non-moving party? So the burden on the motion for summary judgment is always on the movement. It's always to show that no reasonable jury could find for the non-moving party and that there's no dispute of material facts. So that's always in the background, but the way it works out is if the defendant doesn't meet its initial burden, then it didn't carry its summary judgment burden. If it did meet its initial burden and the plaintiff failed, then it's entitled to summary judgment. If both parties met their burdens, then summary judgment should be denied. Now, it sounds confusing, but you'll see it all kind of pull together when we go through these cases. All right, so again, one way to think about things, and again, the much more common way for summary judgment to occur is when the non-movant has the burden of persuasion at trial. So this is the defendant moving for summary judgment on the plaintiff's claim. The non-movant, the plaintiff, has the burden of persuasion on its claim at trial. If the plaintiff has a claim, and these old boxes have for basic a negligent claim, the plaintiff has the burden to show some evidence of duty, some evidence of breach, some evidence of causation, and some evidence of damages. So that's the burden is on the plaintiff at trial. Now look at that heading, because that heading is super important. When the non-movant has the burden of persuasion at trial, summary judgment is determined only by whether there is some sufficient evidence favoring the non-movant. So you look at those boxes there, you look at the left side, and you ask yourself, is there some evidence from which a reasonable jury could find for the non-movant, the plaintiff? If so, summary judgment is denied. It does not matter if there's tons of evidence on the right-hand column. In other words, the plaintiff has one witness that will testify as to facts showing, let's say, breach of duty, right? One witness who will say that it is the defendant who ran the red light. The defendant has 400 witnesses who will say the plaintiff is the one who ran the red light, or the defendant certainly did not run the red light. Those witnesses for the defendant include Mother Teresa, they include the Pope, they include President Trump, President Obama. Only fact that President Obama and President Trump agree on is that it was not the defendant who ran the red light. Senator McConnell and Nancy Pelosi, they also agree that it was not the defendant. There's only one person in the world who says that it was the defendant who ran the red light. You look in that left side box, and if a jury believes that one guy, the jury's going to find for the plaintiff. You ignore what's on the right side when, as the heading says, the non-movant has the burden of persuasion at trial. You believe the evidence favoring the non-movant. You don't look outside of the left side of that column. It sounds like I'm beating a dead horse, but it's a very difficult thing to understand. Summary judgment, the question is, if you look at the evidence in the light most favorable to the non-moving party, could a reasonable jury find for the non-movant? If the jury believes that one guy over Trump and Pelosi and Obama and McConnell, they're going to find for the plaintiff. That's how you look at the evidence. Only look at the left side. Now, after trial, we'll see that there's other things that come into play, but summary judgment is all about, is there some evidence from which a reasonable jury could find for the non-moving party, not whether there's more or it's better or so on and so forth. So how do we go through this process? First of all, the moving party has this burden of production, and I want to make sure again we understand how this works in the real world, and we'll drill down on some on when we go through Celotex. The party moving for summary judgment who suggests, that's the language from old Rule 56, but lawyers still use it, there's no disputed issue of material fact, and it is entitled to judgment as a matter of law. It has to support each material fact with citations to evidence from discovery or affidavits, and make them of record by attaching them as exhibits to its motion, or if they've been previously filed, then you refer back and you say, the deposition of Mr. Smith was previously filed in connection with some other motion. See docket number. You don't have to file it again. Now, in the real world, we just file it again because everything's electronic. It's not like you're making a lot of paper for the court. But you don't have to, but you have to let the court refer to it so the court can find it. So now, recall that discovery requests aren't filed, nor are discovery responses. So this is where I go through the discovery materials, and I put together the deposition excerpts, I put together the interrogatory answers, whatever it is, I put it together as an exhibit to all of those documents as an exhibit to my motion for summary judgment. we'll talk about the we talked about the Middle District of Georgia rule a moment ago. You have to put a statement of facts in and provide a citation to the record, page and line number of where you're referring to in a deposition, exhibit number, if you're using an exhibit to a deposition. So it's really important to gather that material because remember, the court doesn't have it. Discovery responses have only been sent between the parties. Court doesn't get it. Now there's an exception if all you're fighting about is a pure question of law, which happens. You don't have to produce evidentiary material. It's really a 12C motion. You're really just fighting about what the law is, but we sometimes call them for summary judgment. So, sometimes call them summary judgment. Haddle's lawyer could have filed a summary judgment that said, we're entitled to summary judgment because property doesn't include at-will employment agreements. There's nothing wrong with that. But it's just usually what it is we're putting in discovery to show. Usually what it is the defendant is putting in discovery as an exhibit to its motion to show the plaintiff has no evidence of an element of one or more of its claims, or one or more elements of one or more of its claims. So, and we'll get into this a little bit more with one of the problems in the book, or one of the questions in the book. So the burden of production depends on whether the non-movement has the trial burden on an issue. Now again, if I back up to that prior slide, and I'm not going to do it because Lord knows what will happen if I back up with audio. That prior slide is the common one where the defendant is moving for summary judgment, and so it is the non-movement has the burden on trial. So if the non-movement has at trial the burden of persuasion on the issue, so the defendant's the movement on a plaintiff's claim, then the movement must show there's insufficient evidence on at least one element of the non-movement's claim or defense, if it's the plaintiff moving on an affirmative defense. So again, think about this for a second, and again, put it in terms of 12b-6 for a second. Imagine all those little boxes. The plaintiff loses on 12b-6 if there's not factual material in every one of the boxes of a claim. The plaintiff also loses if there's no evidence at trial on one or more of those elements, right? The jury shouldn't give the plaintiff a win if there's no evidence of something it's required to produce some evidence of. Summary judgment, the defendant can come in and show that there's insufficient evidence on at least one element, right? If it could be all of the elements of a claim, but at least one element of a claim. Now there's two ways that the movement can do that when the other side has the burden of persuasion at trial. One is this negating affirmatively, like is in Kress. Kress is kind of a hard case to understand because they've whittled it down so much in the book. But bias, I think, is probably a perfect example of it. In bias, the defendant came in and showed that no insurance company would issue an insurance policy on somebody who used cocaine. So they negated causation in that case, and we'll talk about it more later. The other way to meet the burden of production is to show the discovery materials show the non-movement can't carry its burden of production at trial. And their burden is to produce some evidence from which a reasonable jury could find for it. Sorry about the typo there. So again, my burden at trial is to produce some evidence from which a reasonable jury could find for me. If I don't produce any evidence at trial, the jury cannot find for me. And we'll see how all that plays out if the jury messes up. So what summary judgment does is it allows me as the defendant to come in and say, there's no evidence of an element of a claim after discovery, so let's not bother to try the case, because the way things are, we're going to go to trial, and at that time, I'm going to win. Judgment is a matter of law at trial, what we call directed verdict, or judgment notwithstanding the verdict. And so why bother to have the trial when that's what's going to happen? So notice what this does, and Yezel points this out, is the plaintiff has the burden to gather up the evidence during the discovery period. It can't wait. Now the defendant, there's some exceptions to that, but the defendant is going to make sure that it takes the depositions of witnesses who might give affidavits to the plaintiff to make sure that there's no evidence there. So I'll depose the plaintiff to make sure the plaintiff isn't going to say something that will create that they could write an affidavit for. And we'll deal a little bit with affidavits in some detail later on. So the big picture here is that during discovery, the plaintiff, because it has the burden of persuasion on an issue at trial, knows the defendant is going to file a motion and say there's no evidence of one or more elements of a claim. As a result, the plaintiff has to gather up some evidence of every element, or it knows it's going to lose that. Now, the defendant, that final bullet point under the first point, the defendant does not meet its burden of production by coming in and saying the non-movement lacks evidence, just nakedly saying that. The two choices it has are to negate it affirmatively, so it comes forward with evidence. In bias, they got depositions, they got whatever from insurance companies saying we don't give insurance on people who use cocaine. Or the defendant comes in and says, here is the discovery in this case, and here is why it shows the non-movement can't come up with some evidence at trial from which a reasonable jury could find for it. Those are the two options. It does not have the option of filing some motion that simply says, let me rephrase that, it doesn't meet its burden of production if it comes in with a motion that simply says, hey, the plaintiff doesn't have any evidence, period. It has to show the plaintiff has no evidence. And we'll see that with all the cases, but particularly with Celotex. Now, what about if the movant has the burden of persuasion at trial? So the plaintiff is moving for summary judgment on its claim. Now, you could do this on, and it's not uncommon for a plaintiff to do it on some of its claim, but rarely on all of it. Now, think about it. It has to show that there's sufficient evidence on every one of its claims. That's okay, but it's that next part. Excuse me. So it comes in and it has to show there's some evidence on every element of its claim, and it's entitled to judgment as a matter of law. That means that it has to show that no reasonable jury could come out for the non-movement. Okay, now stop and think. If I come in as the plaintiff and I show I have some evidence on every element of my claim, does that mean no reasonable jury could find for the defendant? In other words, if I come in and I have my plaintiff who was deposed, let's say he got in a wreck and the defendant ran the red light, and that's what I put forward, does that mean that the jury has to find that it's the defendant that ran the red light? It means they can, right? There's some evidence from which a reasonable jury could find for the plaintiff, but does it mean that no reasonable jury could find for the defendant? No, it means the jury may say, hey, the plaintiff's lying. Or, if there was really a car wreck here, they would have had 3 or 4 witnesses. They don't have to come out for the defendant. The evidence has to be so overwhelmingly in favor of the moving party, if the moving party has the burden of persuasion at trial, that no reasonable jury could come out for the other side. So you do the same thing with those two charts, but basically you'd be only looking at the right side of that chart with the little boxes on it. Rare, but it does happen. So we'll cover the JMAL in detail when we get into what is some evidence and what is no evidence. These cases in this chapter are more about what does it mean to meet the burden of production for summary judgment rather than what does it mean that there is some or no evidence. So this won't make complete sense until we hit that. But the requirement of the motion is that there has to be the record evidence has to be such that the district court would grant a directed verdict. The evidence is viewed in the light most favorable to the non-movement. The court cannot decide the credibility of witnesses who dispute a material fact and cannot weigh the evidence. And I went into that some on the last thing. Now, even no response by the non-movement doesn't justify entering summary judgment. So if the defendant files its motion and it doesn't it doesn't negate an element of the claim, or it doesn't show the discovery shows there is no evidence, then the court can't grant summary judgment. And it says can't, it means shouldn't. It may, in which case there's simply an appeal. Entry of summary judgment is appropriate only if the non-movement makes this burden of production, shows there's no genuine issue of material fact, and shows it's entitled to judgment as a matter of law. So what if I'm the plaintiff and the defendant files a motion and it says, I'm entitled to summary judgment because there's no evidence of blank element of plaintiff's claim. That's improper on a summary judgment motion. The defendant who files that naked kind of allegation that there is no evidence has not met its burden of production. So theoretically, I don't have to respond at all, and the judge should deny it. But if I don't respond, I waive my right to controvert facts. I waive my right to respond to legal argument. The court has to accept everything that's true in the motion if they're properly supported by the record. So I always respond, even though technically I don't have to. So I don't know why the last little box didn't show up there. So what does the movement has to show in its motion? That's what Celotex is about. Celotex is addressing the question of when you're filing your motion as a defendant in a summary judgment motion, what do you have to show about the state of the evidence? The language is that you have to show no reasonable jury could find for the non-moving party. But what does it mean? And Celotex gets into that. So in this case, this case was a products liability case, and Mr. Cotret had passed away due to asbestos, getting asbestosis from being exposed to asbestos. So now, and it's important you recognize, and this is something I've said for a long time now, courts decide cases on a claim by claim, plaintiff by plaintiff, defendant by defendant basis. So I'm just going to call him the plaintiff, even though it's really the decedent's wife, or former wife, whatever the right word is, widow. She sued 15 different defendants, all of whom made asbestos products. Okay, she has to show duty, breach, causation, and damages against each one of those. That's her burden at trial. Well, your Celotex, you've been sued for someone has died. Duty, well, you're selling a product. This really is a products liability claim, but we'll just keep it in negligence to make it simple. Duty, if you make a product, you have a duty to make it relatively safe. It's simplifying products liability quite a bit. Breach, well, if it wasn't safe, and that sounds bad. Causation, here's the issue. Okay, he apparently had some evidence that he died of asbestosis. You made a product that has asbestos in it. Asbestos causes asbestosis. How do you get out of this lawsuit? You get out of this lawsuit by showing not that asbestos doesn't cause asbestosis, that ain't going to work. Not that showing that you don't have a duty when you're making a product to not make it safely, but to show that there's no proof he was exposed to your product. Yeah, he died of asbestosis, but it wasn't caused by you. Now, the court talks about how it's proximate cause. I guess that's right. I would think it's more cause in fact. There's no proof it was my product that hurt you, but either way, causation. So the defendant, Celotex, moves for summary judgment on the issue of causation, saying there's no evidence from which a reasonable jury could find that Celotex's product harmed the plaintiff. Who had the burden of persuasion at trial on that issue? The plaintiff. The plaintiff has the burden to show it was the defendant's product who hurt him. So now, was the defendant required to file with its motion evidence that negated an element of the plaintiff's claims? This is where, look over on the Celotex case, and at where it started the case, hang on a second, it says, this is the very first full paragraph. Sorry about that. It says respondent, the plaintiff filed the lawsuit, and that says the Celotex moved for summary judgment. And then look what it says. Petitioner noted that respondent failed to identify in answering interrogatories specifically requesting such information any witnesses who could testify about the decedent's exposure to petitioner's products. So in their motion for summary judgment, the defendant said, look, we sent over an interrogatory, and we said, please identify people who will testify that his asbestosis was caused by exposure to our products. And they said, we don't have anybody who's going to do that. Okay. So now look, what did they do? They showed the discovery material, showed there was no evidence to support an element of the plaintiff's claim that it was the defendant, Celotex's product, that hurt Mr. Cotret. Now, I'm going to drill down a little bit before I go to that next question. It says, what two ways? Actually, let me look over on the right side of the slide. What evidence did plaintiff make a record? Look at the next sentence. And again, remember, motion, response, reply. It says, in response to petitioner's summary judgment motion, respondent, the plaintiff, then produced 3 documents. And it doesn't mean produced in the way document production. Instead, it attached it to its motion as exhibits, which she claimed showed there was a genuine dispute of material fact as to whether decedent had been exposed to the plaintiff's asbestos. And it talks about the 3 documents: a transcript of a deposition of the decedent, a letter from one of his former employers, which the plaintiff planned to call as a witness, and a letter from some insurance company to the plaintiff's attorney. And they all sort of suggested that Mr. Cotret had been exposed to their products while he was in Chicago. Now notice the next sentence right after that. Petitioner in turn. What does that mean, in turn? That means in its reply brief. So we have motion, response, reply. Said, argued the 3 documents were inadmissible hearsay. It objected to them as hearsay and shouldn't be opposed. So then the district court granted the motion, the appellate court reversed. So what 2 ways can the defendant meet the burden of production after this case? Again, one is with this respect to Cress. So the best, it's really hard to find a good place where the court explains Cotret and the difference between negating and not. And again, I think the bias case is the best illustration of that. But the one way is to come forward and negate an issue on which the other side has the burden of proof. And the second way, and I think the best place that they put it is on page 574. It says, in our view, the plain language of Rule 56A mandates the entry of summary judgment after adequate time for discovery against a party who fails to make a showing sufficient to establish the existence of an element essential to that party's case and on which that party will bear the burden of proof at trial. Now, and look at the next sentence and make sure you visualize those boxes of the elements of a claim, and then hopefully this sentence will begin to make sense to you. It says, in such a situation, so they've had time for discovery, and the moving party has showed they don't have evidence of an element of their claim. It says, in such a situation, there can be no genuine dispute as to a material fact, since a complete failure of proof concerning an essential element of the non-moving party's case necessarily renders all other facts immaterial. In other words, if I show there's no evidence of one element of a claim, it doesn't matter if you have lots of evidence of all of the other elements. You've got to have some evidence of every element. So if I show there's no evidence of one, nothing else matters because you lose if you're the plaintiff. So would it have been enough for the defendant, and I know I'm beating a dead horse on this, but believe me, it'll be on the final. Would it have been enough for the defendant to file a motion stating no evidence supports the plaintiff's claim and saying nothing else of substance? No, the defendant has to come in and do like the defendant did here in its motion and show, here they did it through an interrogatory answer, the plaintiff has no evidence. I've sent over an interrogatory. I've asked you for the identity of witnesses who will say it's my product, and you wrote back and said, we ain't got nobody. Therefore, I have shown there is no evidence of causation. So the, sorry, this is the wrap-up. I pushed the button to move it, and then it was the last slide. So Celotex tells us that the defendant in its motion has to do more than say there is no evidence. It has to show the plaintiff has insufficient evidence. And I mentioned this before, but lawyers will say, well, there is no evidence of whatever. What they mean is there is less than a scintilla of evidence, or to put it in terms of the rule, there's insufficient evidence for a reasonable jury to find for the non-moving party. But we just use the phrase no evidence. Your Honor, there is no evidence of blah. Well, we're not saying literally none. We're saying there's insufficient evidence for a reasonable jury to find for the non-moving party, even if you look at the evidence in the light most favorable to the non-moving party. And if you can't tell, by the way, I've said those words, I don't want to say 1,000 times, 100 times. I've written them 1,000 times in summary judgment motions. I've read them probably more than that. This is the language of summary judgment motions, and you need to get comfortable with it. So on the page, what is it, 576 or so, there's some notes and comments. He says, on number 1, he says, everyone agreed that Mrs. Cottrett had to show her husband been exposed to Celotex's products. And then in B, he says, everyone agreed Celotex could defeat recovery by showing Mr. Cottrett had not been exposed to its products. So, like he used in the next question, he says, what if Celotex never made asbestos? Celotex would come in and prove it had never made asbestos, and therefore would win because it could not have caused his thing. So notice it's negating, right? It is negating an element of his claim by proving it could not have been the cause. So what were the parties disagreeing about? Was it sufficient for Celotex to come in and not do that, right? That was settled. It could come in and show it had never made asbestos, or he had worked places but had never shipped asbestos to him. Or was it sufficient for Celotex to come in and show plaintiff didn't have any evidence of something that it needed to prove? And the court said, yes, that was sufficient. So now this next one is where I mentioned I had a little bit of problem with what he's got there. So it says, what did Celotex do to summary judgment standards? Why does it matter? Well, it says, at trial, Celotex defendant could prevail in 2 ways. It could prove Mr. Cottrett was not exposed to asbestos by demonstrating that it never made it, given unlikely that it made asbestos. Now look at what he says then. It says, or it could prevail if Ms. Cottrett failed to show that Mr. Cottrett was exposed to asbestos, perhaps by convincing a jury the sole testimony linking Mr. Cottrett to Celotex was not credible because the witness had been bribed. Okay, well, credibility is always going to be for the jury. So if the only witness had been bribed, then the jury would decide whether that bribe caused that person to lie or not. Okay, so this is what I don't like about what he wrote there. Credibility is always for the jury. So one way it could win is by showing it never made asbestos, negating. What's another way it wins? Another way it wins as a matter of law, meaning no reasonable jury could find for the plaintiff, is if when the plaintiff is done, right, all the testimony is done at trial, nobody has ever testified that Mr. Cottrett was exposed to Celotex's products. So one way is it could prove it never made products, right? Another way is it could prove Mr. Cottrett had never worked at a factory where Celotex's stuff was used. But at the end of the plaintiff's case, or at the end of trial, we will see, the defendant could stand up and say, Your Honor, no reasonable jury could find for the plaintiff because nobody has testified the plaintiff was exposed to our products. No witness ever said anything about Mr. Cottrett being exposed to our products. Notice, it's not, this is what I don't like about what he wrote there. It is true, it could prevail if Ms. Cottrett failed to show that Mr. Cottrett was exposed to its products. That is true. How would it do that? By simply pointing out that they never produced a witness at trial to say that. This part about credibility stuff there is really confusing, and you should just ignore it. Because if the witness testified, yes, he was exposed to Celotex's products, and the defendant says, aha, you were bribed, weren't you? And the witness says, yes, but it didn't affect my testimony, the jury is going to decide whether he was lying or not. It is not for the judge to decide that issue. There has to be no evidence from which a reasonable jury could find for the plaintiff. So the jury may think, hey, the guy got a bribe, but he was telling the truth. So it's kind of an odd thing. The rest of those notes I don't think change too much. But look over on 578. He makes a couple of good points about the the burden of proof issue. So he says, imagine that one of the issues in the Celotex case is whether asbestos causes asbestosis. Not about whose, but about, does asbestos actually cause death? Her complaint says yes. Celotex answer says no. Obviously, Mrs. Catrat has the burden at trial. So he says, A, first suppose that Celotex moves for summary judgment on causation. In support of its papers, it points out no medically qualified expert opined that the asbestosis caused Mr. Catrat's death. Motion. In the response, Ms. Catrat produces an affidavit of pathologist who says he's real smart and he's qualified. He's examined the things, and he has concluded that they're consistent with him having died of asbestosis. Why would the court deny Celotex's motion for summary judgment? Well, you have some evidence from which a reasonable jury could find that he died of exposure to asbestos. Does that mean that the plaintiff has to win? No, but the plaintiff could. There is some evidence. Now it says, the B says, now it supposes Mrs. Catrat who moves for summary judgment. And she files summary judgment, and she includes in her motion that affidavit, which says, looks to me like he died from asbestos. And then in response, Celotex doesn't file anything. Why should her motion be denied? Again, now back up. The standard is exactly the same. Did she show there's no disputed issue of material fact? It looks like it. He died of asbestos, or at least it's consistent with him having been exposed to asbestos. Now, does that mean no reasonable jury could find for the defendant? No, it means a reasonable jury could find for the plaintiff, right? Because there's some evidence he died of exposure to asbestos. But does that mean no reasonable jury could find for the defendant? Particularly when it says, the guy says it's consistent. So where we are is we have some evidence from which a reasonable jury could find for the plaintiff. Does that mean that no reasonable jury could find for the defendant? Does it mean that all juries, just because there is some evidence in favor of the plaintiff, does it mean all juries would have to find in favor of the plaintiff? No, it does not mean that, because the burden of persuasion is on the plaintiff at trial. All right, keep plugging away, and it'll get clearer and clearer as we move forward. Talk to you later. Bye.